if you've recently gone through a divorce, you might be wondering, should I update my estate plan? What happens when, let's say in the past, you and your spouse had an estate plan, probably where you provided for each other and your children, but then you and your spouse divorced, so you're no longer married. Well, it seems rather obvious, I would think, that of course, update your estate plan. A divorce is a major life event that makes a significant difference on your estate plan. So in Washington state, we have laws that say for the person who got divorced and they failed to update their estate plan, Washington state assumes that you really don't want to provide for your ex-spouse. So under our laws here in Washington, even if you don't update your estate plan, even if your old will says everything goes to my spouse, now ex-spouse, the state of Washington will say, well, it's clearly a divorced spouse and the decedent wouldn't have wanted that. And so we're just going to act like the surviving ex-spouse has died, isn't even in the will at all, which I think is a really smart provision that we have here in Washington state. Certainly the reason for that is oftentimes people don't update their estate plan. Don't leave it to the state statute. Update your estate plan. Make sure that you provide for those that you want, especially if you have minor children. When you're doing a new estate plan after your divorce, bring your divorce decree to the attorney, because there may be provisions in that divorce decree that say that you have to do certain things. For example, you might, by that divorce decree, provide for your kids by way of a life insurance policy that should pay to a minor's trust that's created by your will. Make sure your will says who you would want to be the guardian of your children if you die. It may be that you're fine with your ex-spouse being the guardian, or it may be that you say, or maybe they can't be for some reason, that you would want somebody else that you trust to raise your children. That should be in your will as well. One thing I do want to mention, I told you about Washington law kind of having a fix provision if you forget to update your estate plan. Washington law does not change federal law. Under federal law, ERISA, for example, let's say that you have a 401k from your employer, and when you set it up, you named your then spouse, now ex-spouse, as your beneficiary of that plan. Well, then you die, and you haven't changed your beneficiary designation. Your 401k, which could be your largest asset, will pay to your ex-spouse. That's because there's no fix that Washington law has that can supersede that ERISA, whatever ERISA says. So don't leave it to chance. There's a lot of surprises that come when people see the application of laws that they never thought about. If you have a major change in your life, which divorce is, as you know, definitely update your estate plan.